the other critical aspect as far as an arbitration proceeding is concerned is a Section 11 application. Now, where and under what circumstances a Section 11 application becomes important? A Section 11 application comes into play or comes into effect, or you file a Section 11 application is when the other party, when you propose names of a few arbitrators, refuses or chooses not to respond to the notice or appoint an arbitrator on their behalf as their nominee arbitrator. So while you've issued a notice, you've named your nominee arbitrator. This I'm talking particularly in scenarios where there are more than one arbitrator, that is 3 arbitrators to take a particular case, where 3 arbitrators, it's a panel of 3 arbitrators. The first arbitrator, nominee arbitrator, will be appointed by your client as claimant's advocate, I'm saying. The other side chooses not to respond or refuses to arbitrate or appoint its own arbitrator. That is when you need to file an application under Section 11 with as far as Mumbai is concerned, before the Bombay High Court. If it is a domestic arbitration, if it's an international commercial arbitration, in those cases, you file a Section 11 application before a Supreme Court. The other scenario in when a Section 11 application comes into play is when it's a case of a sole arbitrator who's supposed to be appointed by mutual consent of both parties. They have to agree upon one single name. So while acting for a claimant, you issue a notice, name Mr. X as an arbitrator, your proposed nominee sole arbitrator. The other side refuses, come back with another name, and within a reasonable time frame, if the parties fail to agree on one given name, that's when a Section 11 application is moved before a High Court or a Supreme Court, as the case may be. Now, as you all are aware, several amendments have taken place. One in 2019, before that 2015, which brought about a good change as far as I'm concerned, or my view is concerned, is introduction of Section 11(6)(a). Now, why it becomes important that the prime focus of arbitration or the prime focus of the amendments is that reducing the intervention of courts as far as arbitration is concerned. Like I said in the beginning, an arbitration gives a solid party autonomy, freedom to the parties to arbitrate or resolve their disputes by the choice of machinery of their choice. So in that sense, 6A limits the intervention of court to the extent that when a party files a Section 11 application before courts, the courts only have to see the existence of an arbitration agreement and see that the dispute is arbitrable, and then pass orders allowing the Section 11 application. The limited focus of the court is existence of an arbitration agreement. So when I say this, it again gets us back to the critical aspect of an arbitration agreement. Why in the beginning I had said an arbitration agreement should be clear enough and free of any defect to cut out on delays and obviously cost implications, is that Section 11 application becomes a lot more simpler because the court simply sees that there is an arbitration agreement, parties have agreed to arbitrate, so they direct the parties to proceed towards arbitration. So this is the scope of a Section 11 application. When an application is filed before a High Court or a Supreme Court, like I said, it's a limited aspect that the courts have to dwell in. Along with that, as far as arbitrability of a dispute is concerned, in the beginning, like I said, matrimonial disputes or trust matters are by its nature not arbitrable. So those disputes cannot be submitted to arbitration. Unless it's that case, the court will refuse to entertain a Section 11 application. Another important factor where this law relating to Section 11 has evolved and is still evolving, I would say, is the angle of fraud, and then again the serious nature of fraud. If the party who's defending, who is opposing the Section 11 application, is successful in convincing the court that this particular dispute involves allegations or serious allegations of fraud, plethora of evidence will have to be laid in this matter, then the court may direct the parties that in this case the dispute is not arbitrable. But it's a very thin line Whilst on this point, it is very important to also read up. I would not discuss that case. Is the Ayaswamy, famous Ayaswamy judgment, and a few judgments after that, which discusses this angle of fraud and serious nature of fraud and whether such disputes can be arbitrable or non-arbitrable. So, whilst on the point of a Section 11 application, the other critical aspect, if you are representing a respondent, to choose or to nominate your nominee arbitrator becomes extremely important. Why you shouldn't let go of that right is because once a party loses its right to appoint its arbitrator, that choice is no longer with the party once a Section 11 application is filed with the court. On this point, I think you all should refer to a recent reported judgment of SAP India Limited versus Cox and Kings that will give you the importance, or rather highlight the importance of why a party should utilize its right on appointing its nominee arbitrator, because otherwise it runs a risk that it no longer has the right in those arbitral proceedings. Even if the arbitrator, court appointed arbitrator, resigns, the party who has refused to appoint an arbitrator will no longer have a right to appoint its nominee arbitrator. Then, if at all an arbitrator becomes de jure or is incapacitated to act as an arbitrator or resigns as an arbitrator, the parties will again have to go back to the concerned court for appointment of an arbitrator if that particular court appointed arbitrator resigns. So it becomes very important to advise your client to choose and execute their right to appoint an arbitrator at that juncture itself.